5 seconds to go. Start. Compulsion to draw the legal presumption that such gratification was accepted as a reward for doing the public duty. It was further observed that the two witnesses examined on the defense side were unable to rebut the presumptions raised, and hence this court dismissed the appeal and held the accused to be guilty. Another judgment referred to in the reference order, which is a case which arises under the 1947 Act, is Kishan Chand Mangal versus State of Rajasthan 1982 3 SCC 466. In the said case, it was observed that it was a case of entrapment where the complainant had given a bribe and the demand of the said bribe was also present. It was observed that the evidence on record, for instance, the complainant's visit to the Anti-Corruption Bureau, his producing currency notes, and the superior officer of the department making a trap arrangement, and the raiding party going to the house of the accused indicated that a prior demand for payment was made by the accused, and the same was circumstantial evidence. In the aforesaid cases, the common thread which runs through is that the complainant was not available to let in evidence, and hence there was absence of direct evidence. In B. Jayaraj, the complainant did not support the prosecution and hence was declared hostile. In P. Satyanarayana Murthy, the complainant had died prior to examination of 7 witnesses, while in M. Narsingha Rao, the prosecution witnesses had turned hostile. Therefore, in B. Jayaraj and in P. Satyanarayana Murthy, the court acquitted the accused, while in M. Narsingha Rao, despite 2 witnesses being declared as hostile on facts, it was found that the accused therein had willingly received the tainted currency notes, and hence this court sustained the conviction of the accused. It was observed that despite 2 prosecution witnesses turning hostile, it was established by other evidence that there was a demand of illegal gratification. Since the foundational facts were proved, the presumption for payment or acceptance of the same was applicable, which was not rebutted. Consequently, the legal presumption under Section 20 of the Act was also raised and remained unrebutted. In the above said backdrop, the reference was made to the larger bench and ultimately to the Constitution bench. We have heard the learned senior counsel and learned counsel for the appellants and learned ASG and other counsel for the respondents. Shri S. Nagamuttu, learned senior counsel, during the course of his submission contended as follows: that the question for consideration has not been appropriately framed, and hence the appropriate question may have to be reframed by this court. He submitted that normally in a case under sections 7, 13(1), D1 and 2, the complainant is expected to speak about prior demand and subsequent receipt or acceptance of illegal gratification by a public servant. But if his evidence is not available, it would imply that there is no direct oral evidence of the said witness to prove the aforesaid 2 facts. The issue before the Constitution bench is whether the aforesaid 2 facts could be proved by any other mode in the absence of direct evidence, so that the guilt of the public servant could be brought home. In this regard, our attention was drawn to sections 7, 13(1), D1 and 2 and 20 of the Act as they stood prior to the amendment of the Act. Much emphasis was laid on the expression accept or obtain or agrees to accept or attempt to obtain. In the context of section 20 of the Act, which deals with raising the legal presumption with regard to motive or reward, elaborate arguments were made on the difference between acceptance or obtainment. It was submitted that in both cases there is an offer and acceptance of the offer. If the offer emanates from the bribe giver without there being any demand from the public servant, and the latter simply accepts the offer and receives the illegal gratification, it is a case of acceptance as per section 7 of the Act. In the case of acceptance as dealt with in section 7 of the Act, there need not be any prior demand by the public servant. On the other hand, in the case of obtainment, the offer emanates from the public servant, that is, he makes a demand and the bribe giver accepts the offer and pays the demanded gratification, which is in turn received by the public servant. Thus, in the case of obtainment, there is a prior demand for illegal gratification made by the public servant, and in such a case also, both the demand and receipt of illegal gratification have to be proved. This act of a public servant is an offence under section 13(1)(d)(1) and 2, and therefore a prior demand by the public servant is a sine qua non for an offence under section 13(1)(d)(1) and 2. In this regard, reliance was placed on the judgment of this court in B. Jayaraj, P. Satyanarayana Murthy, Kishan Chand Mangal. Thus, if there is a demand followed by a receipt by the public servant, the act of obtainment under section 13(1)(d)(1) and 2 is complete. It is then not necessary to prove motive or reward, as the same is foreign to section 13(1)(d)(1) and 2. Therefore, section 20 of the Act does not pertain to a legal presumption to be raised for an offence under section 13(1)(d)(1) and 2. Stop.